start lah ya. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Let's begin with Ummul Kitab Al-Fatihah. Can you see my screen?
Yes, sir.
Okay. Okay, so this afternoon we talked about topic 10 on internet pornography. You can find the recording. I have already uploaded it on our Google Classroom. So tonight we will talk about fake news. Fake news and false content. Two different terminology. Can be interpreted to mean many things. So fake news, when we had our Anti-Fake News Act, this was a term that is given a legal definition. But now the law is no longer there, it has been repealed. And then what we have under the Communication and Multimedia Act is false content. It is called as false content, and this is also the same terminology that was used in the content code. Yeah? So we know that, as I've explained, we are concerned about the abundance of risky content online, that we have as a result of the expansion of internet, as well as the more netizens we have in the cyber world. So as a result, we are looking at the rise of a lot of positive content as well as negative content, and fake news or false content is one of them, which we are very concerned about. And this discussion is basically, we just want to see what are the laws that regulates fake news in Malaysia. If try to see other countries also have regulated false content or fake news, and we will see to what extent fake news has threatened our cyberspace. So the term false content literally means any stories which were not true. We can find many definitions on false content, which simply means that a story which mislead or causes confusion or mislead the people. We have seen a lot. Actually, this is just a table of summary of false news, false content that has been published on the newspaper. And if you try to see the website sebenarnya.my, I mean on daily basis they updated many news which were to be false in nature, and maybe those that were by sebenarnya.my, they were news concerning government agencies, but there might be many other kinds of content that we can find to be false or misleading. So under Communication and Multimedia Act, we can find the same provisions, section 211 and 233, talking about criminalizing false content. It didn't say, it basically classified this under the general classification of offensive offensive content. So section 233 similar. You are not supposed to use the internet or network facility for improper use, particularly to communicate false content, and this prohibition should be read together with content code So members of the content code must avoid publishing or fake news. Right. Okay, just to highlight to you the case of PP against Dato' Muhammad Zahid Ibrahim. This case was about Dato' Zahid Ibrahim was charged under section 233 for publishing a statement which is offensive in nature with an intent to annoy another person. Okay, so this was This happens, if I'm not mistaken, 2015. The case happens 2015. So upon at the end of the prosecution stage, the accused was acquitted on the following. Remember, this case has to be compared with Rutinin. I want to show to you the how the in Zaid Ibrahim interpreted section 233. So in this case, according to as the judge was delivering the judgment, the judge said that the article must be examined as a whole, not by looking in a few paragraphs or words. So remember, ini dia punya legal principles. So the prosecutor cannot pick and choose relevant paragraph favorable to them and conclude that the article is offensive as a whole. And then the judge looked at the objective of CMA, which is to promote civil society, information-based society, and so on. So the court also considered on the question of evidence, whereby no witnesses found the entire article was offensive. The article has to be examined as a whole, and then finally the intent. But the thing is that I think you still recall in our previous discussion, section 233, the mens rea, you don't have to prove actual annoyance happened. That was decided in Rutinin. But in this case, what the judge did was that the judge had considered annoyance, actual annoyance, to the extent that the judge actually at the to try to see whether anyone has been annoyed by the article. So because of this, when the judge found nobody was annoyed, and then the article has to be taken as a whole, the judge found that the elements of section 233 they were not fulfilled, or the prosecution basically failed in the to establish the case. So that therefore the accused person was acquitted. But this interpretation is different with Rutinin. Rutinin is a high court case, and Zaid is actually a sessions court case. So you know which one is higher. Although it high, very slight. The matter didn't come to Court of Appeal or federal. So the interpretation in Rutinin, similar provision, similar issue, is that it is sufficient that the communication in question has the tendency to cause annoyance or abuse to any person, meaning that you don't have to prove, actual annoyance has happened, and this is the consistent consistent approach that has been followed by many other courts after the decision of Rutinin. So I think for the purpose of basically for purpose of judicial precedent, we know that we are supposed to follow the higher court ratio, unless there is a higher or a more superior court overrule that particular decision. The position remains with Rutinin, that you have to prove tendency. You don't have to prove actual annoyance. This is the position is in UK, whereby, for example, in the case of DPP against Collins, this was about a publication of offensive words. In the UK Communication Act, they have this, the term is grossly offensive publication. So this particular person, they were having conversation with each other, and then they were calling people these bad words. So and then because of this complainant, Collins was charged by means of a public communication system message that were grossly offensive. I want you to bring to your attention to the issues here and then the decisions. The issue here whether what was the correct test for the commission of an offence under 127 and whether the Colin should have been convicted. So this was quite similar to our 233 of the CMA. So in this case, the Court of Appeal basically allowed the appeal, and the Court of Appeal basically looked at this particular, the one I highlighted in red. Yeah. So actus reus was the sending of the message, which is the offensive message, regardless whether it was received. It did not matter whether or not the person receiving the message was offended. This was similar dengan rutin ini. It was a question of fact in all circumstances whether a message was grossly offensive. So it's question of fact, meaning here that the judge has the discretion to evaluate whether that is offensive or not. That's up to the court to determine. And in order for the court to determine what would be offensive, you have to apply the standards of an open and just multiracial society. This is again for the court to evaluate. So in this case, the court found that the messages sent by Colin were offensive, and he has been convicted. And also added grossly offensive to whom? The message should be grossly offensive to whom? To a reasonable person. Here, not necessarily grossly offensive to a specific person, and it must have annoyed that person, but a reasonable person read or listened to this message or this communication, he definitely will feel offended. So this position is, we can say, dia macam in line with the interpretation, yeah. But of course, this is against, or this is different with what has been decided by Zaid Ibrahim's case just now. Okay, as I said, what is offensive has to be judged by the court, according to the standards of an open and just multiracial society. What does it mean? It means that according to a reasonable person. Okay. Right, and the court also said that usage and sensitivities change over time, and there can be no yardstick of what would be offensive, what would not be offensive. So this depends on the time. What would be sensitive in the 70s may not be sensitive in the 2020, something like that. Okay, now coming back to Malaysia, content code. Under content code, it defines false news under Article 7.0 as material likely to mislead due to, among others, incomplete information. Yeah. So Article 7.3 provides an exception where false content is not prohibited when it is satire, parody, or fictional in nature. Okay, meaning content code has provisions to advise the industry. They are not supposed to publish false news or false content, yeah, and this is the provisions that the industry or the code subject with on top of the CMA. Yeah? Okay, because the law has been repealed, remember, don't use this law in when you answer problematic question later in the exam, or maybe in the future if you become a lawyer ke DPP, jangan guna this law unless the law is revived again, because I get in the previous semester I get answer scripts that cited Anti-Fake News Act as if it is still in force. So remember, because of at this time you remember the political drama and all that, so the PH trying to fight for the issues. One of the issue that they try to fight for is the repeal of the Anti-Fake News Act. And so now the law is no longer there. In my opinion, the law is, at least it sets up some path to regulate news. But even with, it's in a way, the Fake News Act is pretty specific. It's pretty specific in regulating and guiding how should we deal with fake news. It's just that certain provisions can be improved. Unfortunately, because of political reasons, the parliamentarian believe that this is against freedom of speech and whatnot, so it has been repealed lah. So saya tunjuk je sekali lalu, this is the definition of fake news which has been defined in section 2. There are some illustration. I think the illustrations, if you read, for example, it's just plainly saying if you don't know, if you're not aware that you are sharing fake news, you will not be guilty you won't be guilty automatically if you shared something unintentionally. I mean, that's maybe acceptable to a certain extent, isn't it? And this the provision or the statute provides a lot of situations or illustrations that basically we can plainly understand. It's not just provisions of the law, but with illustrations given, which is quite clear. Okay, criminalization, basically the act criminalize creating, offering, publishing, printing, circulation of any fake news. And those who provide financial assistance, they can be prosecuted. Everything under this act is basically criminal provisions. And then let's say if you were found to publish fake news, then the affected party can apply ex parte to the court for an order to remove the publication. And you have to remove the material first. If you believe that there's something wrong, you believe that this is not fake news, what you have to do is that you have to remove it first, and then you apply to the court to justify, to set aside the order for removal. Meaning, apa hal pun, you take it down first, you disable access to it first, and then you under section the court if you believe that the alleged fake news is actually not fake news, it's true. So the court will consider. And then the only thing exception to this is that anything, if the removal order was obtained by the government under section 7, then anyone else cannot set aside removal order obtained by the government. So katalah government apply for a removal order against a particular content. When government gets the order from the court, nobody else can apply to set aside under section 8. And body corporate can also be taken action under this provision. The National Declaration against Fake News, it is called UN Joint Declaration on Freedom of Expression and Fake News, Disinformation and Propaganda. Some countries, they use the term disinformation or misinformation. According to them, they prefer this term because it's not really fake news, it's information which is, they depend pada niat orang tu lah. If it's the one that we want to fight is actually misinformation, according to them. Misinformation ni you purposely twisted facts and it is twisted. Disinformation might be misunderstanding, which is not purposeful or which is not intended to be done. People misunderstood something. But misinformation is you purposely create, or you create false information about something, or maybe you purposely have some mal-intention. So this declaration was agreed by many nation states, and accordingly they are basically in line with ICCPR as well. Okay, the first case, and only one case in the News Act, by the way, it's just the case of Danish citizen. If you still recall, this was about this guy posted a video, YouTube video. There was a shooting of a Hamas member in Kuala Lumpur at that time. So at that time, he made this video and said that the police, was it the police or the came late, 50 minutes late. Actually, that was not true lah. So then he was sued, fined under this particular act. After this case, there's no the Anti-Fake News Act is no longer used by the police or the authority. They are instead they use CMA, CMA. Like Fahmi Reza has been was also charged under CMA because at this time the was afraid that if they start to act and then the act was undergoing repeal, so they might be worried that halfway they are doing work and then the act is no longer there. Okay, Malaysia Kini also has been repeatedly sued under this provision as well, and there was also the latest case, that they were, and then again the repeal came. I think late 2019, the repeal came. So remember, the Anti-Fake News Act is no longer around. I heard about some rumors that there were suggestions to revive it, but we don't see any we don't see it coming in a short while. When we had our PKP and then the emergency was declared, remember that was just a few months ago, and then emergency ordinance number 2, essential powers. So this ordinance number 2, this was specific ordinance promulgated or enacted to focus on fake news relating to COVID-19, relating to COVID-19 and its vaccination. So the start of enforcement of March, it was ended somewhere the end of July, or according to the minister, the end of July this year. It was the emergency had ended. So basically the emergency ordinance also offered similar provision to the Anti-Fake News Act. They are basically reviving similar provisions from the Anti-Fake News Act. Sama lah, provision dia lebih kurang sama. But focusing on COVID-19, fake news concerning COVID-19 and vaccination. And a lot of, I think quite a number of people were charged under the emergency ordinance for sharing fake news regarding COVID-19 and vaccination. And most of them pled guilty. So there's no, we don't see any reported cases lah. This is just to show you the form to apply for an order for removal of publication containing fake news. So this is the ex parte application that anyone can apply when the law was still there lah. Okay, and then apart from the law, the government continue to do advocacy efforts, like having a fact-checking portal like Sebenarnya.my. Other governments also do this. They have portals like this to verify which one is fake, which one is genuine, and usually the one that the people would like to know is relating to issues concerning government agencies lah. Usually that is the news that people would like to know the truth of something lah. And then there's also this, I think, similar issue with defamation, or the previous topic that we talked about. There has also been some advisory by the MCMC to ask the administrator to monitor false content. And then the advisory also say that admin are not supposed to be absent admin and so on lah. So this is part of self-regulation, I can say. This is an effort of part of self-regulation, whereby we self-regulate our behavior online. So although the government or the regulator can say they can take action under Section 233, but not necessarily they will take that action unless there is a clear breach with evidence and so on. Then they might take action. But yeah, otherwise they will be suing everybody in the country, kan? So yeah, which is why they are encouraging self-regulation through advisory like this. Yeah. And other initiatives taken by platform providers, like I just mentioned Facebook and YouTube here. Facebook, for example, they have this. You go to their terms and conditions, you will find this community guideline. That's the Facebook policy. The community guideline basically it's the law, the in-house law for Facebook users. And if you are a user of Facebook, you are basically bound by the terms and conditions of Facebook. And for example, with specific focus on fake news, Facebook, they have taken steps to remove selected profiles that were found to impersonate other people, and this is done upon complaints, internal investigation. They also used to create a fake news labeling system in 2017. Yeah? Facebook users can send alerts so that potentially fake stories will be identified by third-party fact checkers. If the third-party fact checkers found the story as fake, the user who shared it will be sent warnings. And then is also of course, later this system was criticized as ineffective, because when the story is flagged with a diluted tag, more people were looking for the content, and hence it is increasing traffic to the news line. So now what Facebook is doing, they are also they are trying to, they don't do that anymore. So what they do is that if they receive complaints about the particular content, I think you can like flag or you can send reports about a particular, and then they will try to, using their system, they will try to hide the news, the news feed too. They will try to hide it in the bottom part so that people cannot, it's difficult to find that, and they prioritize contents published by family and friends. So they don't remove false news, but they show it, they reduce the visibility by showing it in the lower part of the news feed. And YouTube as well, quite a very large user-generated content website. Yeah, YouTube, they have their community guideline as well. They also don't condone fake news, but they have a policy that the platform is supposed to be free from scams, spam, and other. So meaning you can report, and then they will do their investigation. YouTube has this 3 strikes rule. You know, if you were found to breach their community guideline for the third time, first time tu macam warning kot, second time tu tak ingat apa consequence dia. The third time tu meaning you will be banned. They will not allow you access to their account, or maybe your account will be terminated and so on lah. So you cannot have an account anymore. I'm pretty sure that some people will just create another new account with a different email address. That might actually solve the problem for a short while. But for a YouTuber, I guess this is quite damaging, especially when people already know their channel, and then the channel has been been sentenced lah. When it is sentenced, the channel is no longer around. Maybe it will be damaging lah for the channel then. Okay, so that's it for the topic of fake news. So remember, fake news at the moment is regulated by virtue of Section 211 and 233 of CMA, supported by content code just now, that we can also the police can take action under section 515. Kalau tak salah 515. Tadi saya tak sebut kat atas 515, but that is actually in relation to if you publish news that can cause public alarm, that can cause people to feel unsafe, the public can feel unsafe. So that is actually another provision, section 515 of the penal code lah. So dua tu je the law that can regulate fake news at the moment. Anti-Fake News Act, Emergency Ordinance are no longer around. So let's see lah, if there is a new development on this, we will be updating the law, the issue from time to time lah. So let's any question on this, on fake news?
So may I ask if
Yeah.
propaganda is considered as fake news?
Propaganda. Tengoklah, I mean, it depends on the context. If the context is misleading, confusing, not telling the right story, then it may be considered as fake news. What is fake? Really, it's a question of fact. The government might think the story is false, but the people might not believe it. It's a question of fact. That has been a long debate as well on who should determine what is right and what is wrong. So yelah, interpretations kan. So that also becomes one of the problem for fake news law, and it is the government that decides what is right. Nobody else, macam a third party that tells you this is right or not lah. So itu yang jadi problem juga lah, some of the issues that the politicians were debating. Okay, Anin,
Alright, thank you, sir.
So remember, let's say for purpose of examination, you will get, let's say lah, kalau the question is about fake news, you will get a problem, and then katalah you are supposed to determine the liability of the parties, and the fact given was about Malaysia. Katalah it's about Malaysia, so you know Malaysia, the law applicable would be CMA, content code, and so on. You have to fulfill the elements of the section 233, for example. In fulfilling the elements, there are actus reus. Remember, this is a criminal provision. Actus reus ada, mens rea ada. Discuss the elements according to the interpretations that I have shared with you. For example, just now on the mens rea, how do you determine whether you should read the article as a whole or just looking at the title is enough to convict someone? That plays a role in charting a good argument over. Nick nak tanya ke, Nick? Or Ain?
Oh, sorry, sir. No.
Oh, okay. Kalau sempat kita try lah buat soalan. Okay, just nak notify, nanti dalam group juga, this coming Wednesday, insyaAllah we can still have So I will just be doing a consultation. I think if it's not necessary to meet like this, we can have just consultation via WhatsApp. But if you still want me to sit like this, saya tak nak lah macam saya datang, saya tunggu tak ada apa-apa nak tanya. So at least kalau ada banyak nak tanya, then okay lah, we can meet and everybody can listen to everyone lah. Tapi kalau datang macam krik, tak ada siapa nak tanya apa, so might as well I entertain specific questions that you ask lah. But if you have problems ke apa, I can talk privately with the group as well, no problem. Katalah any groups would like to come and talk to me private to ask some questions, boleh je. But you let me know earlier, we can meet during the class hour. Otherwise, might as well I just let you do your work, because you have 3 weeks to do this. You can during the class time as well. So Friday there will be no lecture because we have done our replacement. This coming Friday, no lecture. Yeah. Kejap, tengok kalender jap. Yeah. Alamak. This coming Friday and the next coming Friday, no lecture. So kira balik kampung. Nak balik kampung 24th and 31st. Tapi hari Rabu tu, if you need some consultation, you can text me prior, and then if we can have a Google Meet consultation, no problem lah. So 24th, 31st, no class. InsyaAllah we'll meet you again on 7th of January. Lambat lagi lah tahun depan. 7th of January. On the 14th, we will be having the symposium, but we cannot be, saya rasa saya tak sempat lah nak buat kelas. Sebab the whole day will be occupied by the symposium lah. And our final class will be on the 21st of January. Right, any other question? So tak ada, let's call it a day. Thank you for attending. Let's close with tasbih kafarah and suratul As. Thank you. Assalamualaikum.